Thank you for viewing this innovation vlog brought to you by Prosecutor Center for Excellence in Equitas. My name is Sophia Roach, and with us today is David Angel. He is the Assistant District Attorney of Santa Clara County. David started with the office in 1995 and has worked on several essential reforms, including the establishment of one of the first DA-led conviction review units in the nation. He's here to talk today about the District Attorney's newest project, which is automated expungement. So welcome, David, and we'll start off with having you talk a little bit about your jurisdiction.
Sure. Well, thanks for having me today. I think this is an interesting program, which other people might find helpful. Santa Clara County is in California. The main city is San Jose, although most people probably will have heard of Silicon Valley. This is really the heart of Silicon Valley. But it's a very diverse county, from Palo Alto, which is very high tech, and where Stanford is located, down to Gilroy, which is more of a rural and ranching community. We have about 2 million people in the county and about 200 prosecutors in our office.
And so tell us a little bit about how the idea of automated expungement came on your radar and how it's expanded.
Well, it really stems from our experience with cannabis expungement. As you may know, in California, like in quite a number of places, views changed and the people legalized most possession of cannabis or marijuana. And so we thought it'd be a good idea to try to get expungements for people who had those convictions in the past. In other words, they had a criminal record for something that was no longer a crime. And this was something that we really were responding to input from community members. This was something that was very important to a lot of members of our community. So the DA instructed me at the time to look in how we could achieve this. And as anyone who's a prosecutor knows, this is actually a lot trickier than you might think, because a DA, of course, cannot expunge a record. It has to be done by a court. And a court can't expunge a record unless the case is brought in front of them. And that, of course, brings you to your first real hurdle, which is if you have thousands of expungements you need to do, maybe even 10,000, how are you going to bring 10,000 individual motions in front of a court? I mean, the judge just can't do it, even if she or he wants to. And so what we did is we decided we were going to do a novel legal approach and then combine that with a novel computer tech approach. The legal approach was essentially to determine which cases were eligible, which individuals were eligible for this relief, and then essentially bring a small series of legal motions in front of the court. Each motion was going to do one and only one thing. And then we were going to caption it with thousands of cases in that one docket and with an appendix that listed all the individual cases. We then sent this to the public defender so that they could screen it and decide if we had made errors, if there's people we missed that we should have included, which there were some, so that was very helpful. And then we went to the court saying that this was a proposed stipulated order. We told the court, of course, what our plan was. They were extremely helpful and agreeable. And so we could, with one signature, essentially effectuate thousands of motions in one hearing, as opposed to thousands of hearings. That then brought the second problem. How do you actually get these records cleared? As in most places, this has to be done through an electronic data management system. And that's when we turned to our staff here. And while I can certainly refer folks who are interested, I can't speak to how they worked their technological magic, but essentially they worked out a system of what's called structured data so that this data of all these cases could be synchronized to the local and state criminal justice offender databases. And that's why we did every motion would only do one thing, because you can't ask a computer to make a series of judgments, like if this happens, reduce it to a misdemeanor. If that happens, clear the record. If this happens, eliminate the fine. Each motion just did one thing, not unlike a line of code, so that when they got that appendix, they could then have their digital management system tell the record to do one switch. And then by having a series of signed motions by the judge, I think it was 3 or 4, we were able to make the changes on all the dockets that needed to be made. So that was our experience with the cannabis conviction. And I remember the lead prosecutor who was working on that said, hey, it's like we built this freeway. Shouldn't we drive other things on this freeway? And that planted the seed that made us think we should do this for all appropriate records.
By the way, a very California analogy.
Yeah, exactly. We do love our freeways.
So after you've decided to kind of expand this program, talk a little bit about the process that you use to determine who would be included and how you could use some of the practical data that's already in your criminal data management system to kind of filter and sort out who else might be eligible.
Well, what we began to think about is I'm sure many prosecutors have had the same experiences I've had, that when you have people who've been convicted of crimes and they have a parent or they themselves or professional class or middle class, they will then hire a private attorney who will make sure their record is cleared pursuant to law when the time comes. But the vast majority of people charged with crimes don't have that benefit. As with everything else, we don't want the type of justice you have to depend on your affluence or educational attainment or sophistication. We began to think that this should be something available to everyone, and would be part of our social contract that we would like to make with the people of our community. And to the defendants in our community, that contract says, we'd like it to say, hey, if you do your part and you successfully complete probation, then we will do our part and try to clear your record to help you, both to honor that, to acknowledge it, and also to help you get loans, get housing, get jobs, get educational opportunities, all that can be held up by conviction. And of course, I don't need to tell anyone there's a important and troubling racial bias within our criminal justice system. And so these disabilities disproportionately affect people of color and poor people. None of that is tolerable. And so that's why we wanted to try to address it on a larger level. So what we're starting now, it's a huge task, as you might imagine, every criminal record. So we're starting off, our pilot project is trying to take a single year. And then we're starting with court probation cases. Court probation cases in California, I don't know if other states have this exact same system. They're generally felonies and some misdemeanors, but they're people who are not going to prison, and they're put on court probation as opposed to formal probation. So almost by definition, it's the less serious charges. On the other hand, it's like a pyramid. The vast majority of our cases are lower level cases on the bottom. So we thought this would be a good place to start because we would affect like the vast majority of our cases. And on the other hand, we could see how it works before we moved on to the more serious ones. Right. What we then do is we took a year, we pulled all the cases that had been put on court probation. We then excluded those charges that were statutorily excluded. We were comfortable with the charges that were left. Now, under the traditional system, it's left to a very subjective assessment of whether someone successfully completed probation or not. Mm-hmm. And that leads to a lot of variety. Some probation officers will say, hey, you missed this one class, and so you didn't successfully complete it. Others will have a more holistic view. The DA decided, in a way, we don't really care if you did all your classes, but you reoffend 6 months later, you didn't really successfully complete probation. Because the whole purpose of probation is to help people, restore themselves to a law-abiding lifestyle and life, a productive life. And on the other hand, if you missed 30 classes, but in the end of it, you got it because you no longer were committing new crimes, we were going to deem that you successfully completed. Well, that also made it pretty easy to screen. All we had to figure out is if they were charged with a new crime. Once we got this list, which was a very large list, close to, I think, a little over 10,000 cases from that 1 year, we then went to our Department of Revenue. Now, we have adopted a policy in the last few years where we no longer seek fines and fees for indigent individuals. That's a whole other story. But we decided we weren't going to exclude people from record clearance just because they owed fines and fees. However, if they hadn't paid victim restitution, we were not going to include them in our automatic expungements, and instead try to send them a letter saying, hey, you could get this expungement if you would just pay off the victim of this case.
Mm.
In this way, we're hoping this will actually help victims by motivating people who maybe just haven't made that last payment or two. And then we're doing the exact same methodology that we did with cannabis. Now, I will add, the legal part of it is a little bit more complicated. The tech part of it is much more complicated because there's so many more variables. And we are still in the process of working that out. We've done a few hundred now successfully, but every time we do it, we find new data problems that trigger in one of the systems. But as those happen, they figure out what those are, and then we kind of improve the process. Our hope is to have this fully automated so that rolling forward in the future, whether it's once a month or a few times a year, we'll be able to come into court with a list of all the eligible people from whatever our target year is, and have all those records cleared. And of course, we'll just bake this in going forward. So everyone will know, and I think be incentivized to successfully complete their probation, and then they can have a record that allows them to engage more fully in their lives.
Now, you've talked about partnerships with the court and the public defender's office. Are there any other community partnerships that you leveraged or that you kind of shared some of this information with as you moved forward? And this may be a different type of innovation than we normally talk about, so it may not be as pertinent, but I'm just curious.
Oh, absolutely. Well, we have a really, I think, terrific reentry center in Santa Clara County. And that is what it sounds like. It's for helping people reenter after they've left the jail and sometimes prison or diversion. I mean, in other words, we bring it's one agency or one entity in which people can kind of go for whether it's housing, mental health, drug treatment, clothing for interviews, counseling, and so on. Part of that organization has people with what is described lived experience who've actually gone through it. And so we've tried to include them from the beginning to get their feedback, to get their information. What's really was interesting to me was the individuals with the lived experience who had gone through our jail system, you know, as people who had committed crimes, served their sentence, and now had come out and were thriving. They were the ones who really wanted us to emphasize how this would apply to people going forward, because they believed it would really speak in a language which would support people in kind of turning that corner. And perhaps when they felt like, why even try? What's the point? This would be yet another thing that would remind them that there was really a better future ahead of them. And we've also worked with some of our community-based organizations to try to spread the word, but I've tried not to lean too heavily on that yet, because we haven't actually,
Right.
You know, once the pilot project is done and we know it'll work, then I want to get the word out more. But I don't want to, you know, inspire hope until we know we're ready to go.
And in terms of the changes you've already made, have you seen kind of a dramatic change in the number of expungements that you're seeing in a given month?
Well, yes, we're doing exponentially more than can be done under the traditional method. The goal, of course, is once it's a lot of work up front, but I'm also optimistic that this will result in huge cost savings in the end for the county, right? Because under the traditional method, a public defender, most likely, is going to be spending time in, researching an individual case. That's going to then go to probation. That's going to again go to the office of the district attorney. That's going to then have a court date. That also means you can't do other things during that court appearance. And my county, I'm sure like every county, as prosecutors, we really want to get trials out. We really want to handle things that are directly related to public safety. But these are important too, and they're related to justice. Well, if we can do this on the front end, I think in the coming years, it'll really ease up resources that can be then prioritized for other needs. So while that wasn't really our motive is we do think this is a program that is justice forward. I do think it will be a win-win, because I think it'll help us in some of our more traditional prosecutorial functions as well.
Thank you. Any other suggestions or lessons learned that you wanted to share? You've given us a lot to think about.
Well, I think it's a terrific program, and I do think that there is a lot to be said for at least thinking differently about many of the traditional methods we use in the criminal justice system. Our traditional methods, to their credit, are very individually based. What did this individual person do to this individual system? And then you have a contested hearing or trial on that. That's a great system for certain types of problems. but it's really ill-suited for other problems. And it's very time-consuming. For systemic, when you want to make systemic changes, it's probably not the best tool to use. So I think that's a very interesting and I have found profitable way for prosecutors to just think about using our tools and our systems a little differently depending on the problem we're trying to address.
Well, thank you for sharing this innovation with us, and we want to thank our viewers. If you would like to share an innovation, please contact PCE directly. That's contact PCE at pceinc.org. Thank you so much.
Thank you.